And then there's something more common sense based that the court cites in its opinion, shooting down Mr. Heppner's argument. The Anthropic policy, and for those who don't know, Claude is the Anthropic AI model. The Anthropic privacy policy or terms of use basically permits them to release information regarding queries and inputs and outputs to, guess what? Law enforcement and government regulators. And that's exactly what happened here. So the court cites that Mr. Heppner really had no expectation that these inputs and outputs from his queries and his back and forth with his AI would actually be private at all, regardless of how he and his lawyers tried to dress it up in a confidentiality presentation. I love one of the concluding sentences in this part of the opinion. The judge writes in sum and substance that it's textbook law that non-privileged communications are not somehow alchemically changed into privileged ones after being shared with an attorney. And that's exactly what was happening here. Mr. Heppner did all these things without attorney input and guidance, and then try to run behind his attorney to say, hey, this isn't something that we talked about. Shouldn't this fall within the attorney-client privilege? Court had no compunction about basically shooting that down. So how does this kind of fall into or kind of spill over onto personal injury cases? Well, clearly criminal investigations are different than a personal injury claim, which is a civil claim or lawsuit.